My name is Jan Haagenson, and I've practiced law in the federal courts as a public interest and environmental lawyer for the past 25 years. I was maliciously attacked by the courts for representing my clients who were damaged by an environmental crime which the government wanted to conceal. Large amounts of toxic waste were illegally transported and dumped in my client's rural community and in their backyard, bordering on the Allegheny National Forest. The federal judge who heard their case helped the government to destroy the evidence of this crime. After the judge dismissed all of their claims on the pretext that he lacked jurisdiction to hear the case, and after all appeals had been filed, the judge sealed the record for 10 years without notice to us and without any public hearing. State court judges who had nothing to do with these proceedings accused me of obstructing justice for challenging the district court judge's orders on appeal. My clients had an absolute right to appeal the judge's orders, including his denial of their FOIA inquiry, which demanded all test data procured by state and federal regulators in regard to the environmental crimes which seriously damaged my clients. My clients had a statutory right, as mandated by FOIA, to appeal the trial court's denials to the Third Circuit Court of Appeals. The Court of Appeals remained completely silent and said nothing concerning proper and timely presented legal questions and actions when they had a duty to speak and a duty to honor their oaths of office. Nothing in the federal FOIA statute gives state court judges the right to punish a federal lawyer who has taken an appeal on behalf of her clients to a federal circuit court. Not one word in the text of the statute makes this possible. The state government should not waste its time on theories that violate the Supremacy Clause of the U.S. Constitution. The Commonwealth of Pennsylvania has no power to make original findings of fact in a federal case or to act as an appellate court which reviews federal law on its merits. When a state court makes original findings of fact or attempts to in a federal case, it is obstructing justice. This is true obstruction of justice. When a state court is ruling as if it is an appellate court, when it attempts to review federal court proceedings on the merits, it is obstructing justice. Now, state court judges claim that they could sanction me because I filed a petition for cert in the U.S. Supreme Court, and this is absurd. Pennsylvania's judges are not Supreme Court justices, and they do not decide the merits of Supreme Court cases. They ought to be disciplined for such a shocking and egregious abuse of power. They do not decide who has the right to be heard in the U.S. Supreme Court. Federal law forbids state court judges from punishing a federal lawyer for pleading her client's cause in the U.S. Supreme Court. Federal law should not tolerate these abuses from state court judges who've routinely violated the Supremacy Clause, professional rules of conduct, state and federal law. Pennsylvania State Supreme Court has no right to repeal federal law. They lack jurisdiction to punish any attorney who effectively represents the interest of her clients in federal court proceedings. My clients, had every right to invoke and seek the protections of the laws of the United States. All citizens and their lawyers have a right to search for justice in the courts of our republic and cannot be forced to take their claims to the antebellum courts of individual states or be controlled by the Confederation of State Court Judges who do not know how to honor the existence of the Union or the sacred trust of our federal Constitution.